We're going to shift it to a question for our probate candidates, and we'll start with you first on this one, Ann. The question is, in regards to temporary guardianship of minors, how will these filings be handled? Will a hearing be set to hear all the reasons for the guardianship? For example, is it necessary or are these being filed for the sole purpose to get the minor in the Fayette County school system?
All right. Georgia law does not require a hearing on a temporary guardianship for a minor as far as an actual physical appearance before a judge. It can be judged on the paperwork. But my understanding is that there is something of a problem. I mean, we came to Fayette County for the schools, and I know other people do too. And I think that people do these, I'll call them sham guardianships, where they're trying to, they on paper go into the probate court, start the process, so that they can let a relative who lives in Fayette County get, quote, temporary guardianship of their child, and that the document will allow them to enroll the child in school. My thing is that I'm going to require strong proof of residence of the person applying and proof that the child is actually living with them. It's not going to be a sham situation. You can't just walk in, swear that the child lives with you, and then the next day the child goes back to Clayton County living with their parents. So that I'm aware of the problem, and that's how I intend to address it. Hearings, unless it's mandated or there's some special circumstance that will require the hearing, they typically can be handled without a hearing.
Yes. I think one of the first things you have to do in a situation like that is determine what the temporary guardianship is for. If you're talking about trying to get a child in the school system that wouldn't qualify otherwise, you've got to look long and hard at that. Also, there's a different route they can take if they're really serious about it, is go back through divorce court if you're talking about two parents, one living in one county and another in the other, and switch custody if they're really serious about that and they feel that's in the best interest of their child. As Steve said, you have other guardianship questions and issues that arise where if the child needs to be with a parent in this county as opposed to a parent in some other county, then you have to take a long, hard look at that and make the decision and go with it. Certainly you got to go with the law. Whatever the law dictates to you to do, that's what you got to do. But where there is discretion, of course, it's upon the judge to exercise that discretion, make sure that they understand all of what's going on rather than just rubber stamp a request for somebody to live with another person in this county. I do think there has been a problem with people wanting to come to this county to go to school only.
We do have a question specific to Ann Jackson. What type of cases do you hear currently in Fulton County?
Right. As a hearing officer in Fulton County, I hear all of the adult guardianships. That's going to be any case where a guardian or a conservator is needed for anyone over the age of 18. So that will include people who are injured in car accidents but are over 18, and it may include elderly people. I also hear the citations of fiduciaries when the court is informed that a fiduciary, that could be an administrator, an executor, a guardian, or conservator, is not doing their job properly, or there may be some allegation of mismanagement. I hear those cases also, and I hear a variety of cases as especially appointed by the current probate judge, who is Judge Pinky Toomer.
Thank you. All right, and then another question, starting with Jim. What specific changes would you make within the probate court?
Okay, the idea of change has come up a lot because our court is very good. That we have here, probate court in Fayette County is very good. And so you don't want to take a good court and mess with it too much. As far as the changes I would make, I don't know all of the changes that I would make, but I'll tell you this. I look at the end result, and I've campaigned in every speech that I've made, I've mentioned simplicity. If there's a way to make the court simple, I'm going to make it simple. And if that involves a change, I'll make a change. And if it doesn't, then I won't make a change. We have a good court. I mentioned a few minutes ago some of the craziest people I've seen have been people in robes who are really smart. I don't want that for our court. What I'd like to do is look for a good way to make it simple and apply the law. If you know the law and apply the law and keep it simple, I believe that's what the people of this county want. I don't believe anybody wants to come into court feeling intimidated or come into court and think, well, I don't know what's going on. I don't know what happened. And go back home and the people say, what happens? I'm not sure. That's not a good program for me. So that's the point. I'm not going to make any changes unless it's based on simplicity.
I can't think of anything right off the top of my head. We need to get into the office and actually work with the employees to see what the functioning is. I'm well aware of what the legal requirements are in the with constitutional and statutory requirements for running a court. So I'm not in a position right now to say what changes I will make. I will, of course, make sure that the court keeps up with the law as it changes. That's something I've always been on top of, and I will continue to do that. The court's jurisdiction, I think Steve may have mentioned it or was going to mention it, is going to change in, after 2010, and that's going to be a big deal. We're going to have jury trial jurisdiction in the probate courts. We're going to have appeals directly to the appellate courts. We're going to be able to, the court will hear cases that it otherwise did not hear, such as trust matters. And so you just have to kind of roll with it and make sure. I've worked in a court that's had all those functions, so I'll be able to implement the changes pretty well.
Since we are the Republican Party sponsoring this, I want to ask a political question. To all candidates, which candidate will you support for president in November? And since 2000, have any of you voted in a Democrat primary? And I guess that'll be it for now. I'll start with Jim. You can go right down.
John McCain, I'm voting for in November. And no, I have not voted in a Democratic primary. Don't know anything about any of those people. But I voted Republicans. Know a lot about them, and find a good Republican, vote for him. And let me say, while I'm up, I'm a Republican myself. I'm on a Republican ticket, but beyond that, I'm also a Republican, dues-paying member of the Republican Party here in Fayette County, and have been for several years.
I have voted Democratic. I did in the last primary. I did because I was concerned about where this country was going. I voted Republican before that. I will be voting for Mr. McCain. The reason I'm voting for Mr. McCain is because I believe Senator Obama's experience is just not significant enough to get us through this gap.
This is for the probate court candidates. Forgetting the usual campaign rhetoric, very qualified or most experienced, what would be your second best contribution to the probate court and to the citizens of Fayette County if elected?
We'll start with Mr. Whitlock.
Of all the criticism I've made about judges that were very knowledgeable, and that was about it, I think what I bring to the table is very, very important. I was judge for 12 years approximately between the city of Fayetteville and the city of Riverdale. I had a chance to interact with a lot of people, and I found that the thing that helped me most to be able to understand those people coming before me and make a good ruling was what I understood from the people I'd represented for 30 years. For 30 years, I've interacted with people, gone to court with them, and you've all heard the story said, whatever, be sure and tell your lawyer everything you know. Well, a lot of people tell you more than they know. But anyway, you get to learn from those people. You learn when they're afraid. You learn what they didn't understand. You learn when they come out of court thinking they didn't get justice. And because of that, I think I was a better judge in the positions that I've held so far. I believe I would be a better judge here in this capacity because of what I've learned from the people I've represented. And I'm going to do the very best I can to continue that process and the people that are not represented by an attorney by talking with them and finding out where they're coming from.
I'm going to hit the ground ready to work, and I think that's going to be a benefit. I know what each person here who has been in a probate court in Georgia, if they've been involved in a proceeding, I know what that proceeding is, and I know what you've been through, and I know how to help you through it if you have to be there in the future. I deal with thousands of customers, constituents in my work. And I know exactly what they need to get done. I know the hard times that they are in when they are trying to get these processes done. And I think that you will find I will be a particularly compassionate and knowledgeable judge. I ask for it.